agenda items. Next item is a public hearing. Is item number 1, a review of Administrative Appeal 2012-01, revised staff measure concerning CUP 2001-16 for 444 Main Street.
Good evening again. In January of 2012, at the regular Planning Commission meeting, they chose to approve CUP that would allow alcohol by the glass at 444 Main Street. Some of the background is that this place, this location has been a bar or nightclub off and on for many years, but most notably it has been vacant for the last 7 years. A CUP was granted for this property in 2001, and a CUP runs with the land. The Planning Commission chose in January to modify this CUP and take out references to the former bar and add some security measures and other requirements that the Chief of Police requested being added in. And they chose not to apply the new parking standard. When they had this meeting, they were actually given 4 options when they looked at the 2001 CUP. The options were to modify the existing CUP, to modify the existing CUP and impose a new parking requirement, to revoke the existing CUP, or to not revoke or modify the existing CUP. In other words, let it sit exactly as it is. In accepting this appeal, the City Council has those same options that the Planning Commission had. The CUP, as I said, was modified in January of this year, and within the required 10-day appeal period, an appeal was filed. And staff took the minutes from the January meeting from the Planning Commission, and we took them to the February meeting and had them approved with the staff report, which was attached in your packet, so you have a little bit more background. Also, staff has distributed, and you should have each had in your mailbox, some additional background information, copies of the old CUP, copies of letters that were presented to the Planning Commission and Council years ago concerning problems with the site. So hopefully you all have a pretty good background of what has happened here. We do have the applicants as represented here tonight, and we are both available for any questions you may have. As I had said at the beginning, the Planning Commission chose to modify the existing CUP and not add the new parking requirement. Thank you.
Thank you. Thank you. General comment?
Thank you, Mayor, members of the council. I'm Adam Newman, sitting as the city attorney for this item. I just wanted to advise the council that our recommendation is that, given the importance of this matter, that after the council discusses this item and hears all the testimony, that we will, in all likelihood, be recommending that you carry this item over after giving your direction as to the which of those options you would like staff to follow, staff to work to implement. And then what we will do is, based upon all of the evidence and the council's direction, go and prepare draft findings and an appropriate action to implement the council's direction, and then that would come back on either the consent calendar or the regular calendar for your final action at a future time.
Good, thank you. Any councilor have any comments before the public? Okay. I'll open up to this public hearing, so I'll open up for the citizens' comments and assessment committee. Anybody wants to comment on this item? Excuse me, I'm sorry. Can I have the opportunity, if you want to make a statement first before?
That's okay. Okay.
Catherine Shell Rodriguez, P.O. Box 163. I would like to know what the exact reason for the appeal was. What conditions in the conditional use permit or series of conditions in the conditional use permit did the person filing the appeal find objectionable?
The appeal form does not require that level of specificity. We've reviewed the appeal form. The appeal is in order, and I don't think unless the mayor called up the item, and I don't believe that he needs to state additional reasons other than those that are in the form and available for the public for review.
Good evening, Mayor, members of the council. My name is Mike Ward. I'm an attorney from Turlock, 2350 West Monte Vista, Turlock. Ms. Rodriguez's question was, I thought, fairly pertinent, and I'm not sure about the answer that we just received, because the basis for the appeal, as stated, is that the matter was interesting. And I'm not sure that that forms the basis of providing any notice to anybody to be able to respond appropriately to any matters that are raised today. And so to have a public hearing or have a discussion after you close the public hearing, I would ask that you reopen the public hearing so the matter can be addressed, or at least set it for a further hearing so that the members of the public can address the concerns. Because right now, the notice for this appeal says that they found the decision interesting. I've never seen an appeal based on that basis, and I'm not sure what advice the mayor may have received in order to prepare that, but I think it's improperly vague, and it's frankly probably unconstitutional, because it doesn't give my experience an opportunity to address any issue, because nobody knows. The public doesn't know. Nobody knows what the issue is here today. The second issue I'd like to address is that I don't think the appeal was timely, because I don't believe there was ever an appeal filed with the city clerk. The only appeal that I've seen is the copy that's in the packet, and it looks like it was delivered to the city manager, and that somehow the planning department received it, and it was marked stamped. And so my understanding is, and it's referenced in the staff report, that this appeal was filed with the city clerk. And so I've not seen a copy of what's been filed with the city clerk. It's not in the record, and if it was filed with the city clerk timely, then I would withdraw that objection. But if it's not been filed timely, then I think you have a problem with respect to the filing of that appeal. Let's also speak about what happened, what is discussed here. Donna indicated you have several options in front of you, and it sounds like one of your options could be that you could decide to de novo, on your own for the first time, revoke a conditional use permit that's been issued for that location. Your code section is very explicit, and it indicates that any person may appeal the decision of the planning commission. It doesn't say that you get to make a decision that they were given, the options that they were given, and pick your own decision. Your code section is very specific, and it says that the decision that was proposed, or excuse me, the decision on the proposed revocation or modification is what's at appeal. And the decision here by the planning commission was to modify the conditional use permit. So it would be our position that your review, provided that the appeal is timely, would be to make a determination on whether or not it was appropriate for the council for the planning commission to modify the conditional use permit. If you find that it wasn't appropriate for them to modify the conditional use permit, then their action would be set aside, and we would still be sitting on a conditional use permit. And let's talk about the conditional use permit itself and what really has happened with Mike Sperry. He came in June of last year and requested a business license. The normal process for a business license is you fill out an application for a business license, and the planning department or the appropriate department reviews the zoning, and once they review the zoning and parking requirements, they sign off on that business license, and the next step is Another department will use it for occupancy. You know, the building department and the fire department will make sure that it's safe and appropriate to occupy. We never got to that step because for some reason it just never happened. And so eventually when the Planning Commission reviewed this, they reviewed it because they said, well, nobody's used this conditional use permit for a long time. And therefore we have the power, the planning director has the power to revoke or modify a conditional use permit if it hasn't been active for more than a year. We understand that, but had the business permit been processed properly, it would have been an active use. And it wouldn't have been an active use, and there would have been no reason to bring it back for that basis at that time. But the business permit, the business application sat and nobody returned it and nobody made a decision on it. Ultimately, there was a discussion about parking requirements. And my interpretation of your parking requirements, although they're not crystal clear, indicate that when you build a new building or if you've got some new structure, you're going to have to comply with the new parking requirements. I don't read it to indicate that if you have an existing building that's gone vacant, the new business must comply with the new parking requirements. And if that's the case, you're pretty much going to kill your downtown because no new business is going to be able to comply with your parking requirements if they're going to take an existing facility and if that's the standard. I may be misunderstanding what the basis was for the parking, but I don't think I was. At any rate, at some point we received information that the parking requirements were probably not going to be applied to this application, this business. So today, again, we sit here at an appeal where we really don't know what the issue is because, again, the appeal was based on it being interesting. And we don't think it was timely filed. And then the last issue is I'm not sure, I know the mayor has filed the appeal, but I'm not sure whether the mayor did it in his capacity representing the council or just as an individual. And the reason that's important is because if the mayor did it as an individual, he was required to pay a fee for the appeal. And if he did it in the capacity of the city council, I don't believe the code authorizes the city council to appeal a decision of the planning commission because your code says any person may file the appeal. It doesn't say the city council may call up at any time it wants a decision of the planning commission and review it de novo. So we've got a few different issues here. The most important thing for us, and the reason I'm addressing these is mostly to preserve the record because we're talking on an issue where we don't really know what the issue is specifically, and we're doing it before you comment, and I want to make sure that you don't comment and the public hearing doesn't open again and we don't have an opportunity to be heard. The real objective here is to find out what the problems are and to see if we can address the problems, work with the problems, and open a business that satisfies your concerns. So I hope that you keep that in mind in your discussions, and as we move forward, we're able to do that and avoid spending a lot of time, money on lawyers. And this should be something that the staff should be able to handle. This is an existing building. It's a fairly simple license request. The impacts, I think, in terms of safety that have been addressed in terms of the police department. And most importantly, you've got a 6-month review on this business. If something is not going well and the public is being harmed by this business, you can terminate the conditional use permit. You can further modify it. That's a condition that the Planning Commission, they didn't just make a decision 5-0 for no reason. They considered what was happening, and they've got good conditions here. So I appreciate your time. We're here to answer any questions you may have, and if you comment, we'd appreciate an opportunity for the public to comment again further. If you want to discuss it further and we come back at another meeting and have a public hearing, whatever, we just hope we have another opportunity to hear if there are issues that need to be addressed. Thank you very much.
Thank you very much.
He didn't sign it. Do you want him to sign it?
Yes, please.
Sorry.
It kind of helps him with the order.
Yeah. Thank you.
May I know that I only have
My name is Colette Albernas, P.O. Box 255. My concerns are the same that I had beforehand. By nature of a bar, people drink. And I really became concerned after I made my public comments and the acting police chief got up and spoke. He said that there isn't adequate parking and people will park in Rite Aid. And my mind thinks, they're going to drink at the bar, they're going to leave the bar, they're going to go to their car, and they're going to drive. And I shop at Rite Aid in the parking lot, and I've got my kids. I don't want to get hit by a drunk driver. It doesn't take much alcohol these days to be considered driving under the influence, and your police chief could give you more information on that. I shop at Liberty. We shop at True Value. I don't want people driving in my downtown area that is under the influence of alcohol. My question is, will this bar facilitate people driving under the influence of alcohol? By the city of Livingston allowing this bar to go into a vacant building, because it has been vacant for many years, will we be facilitating, in a small manner or a large manner, DUIs? Will somebody be hurt? The other concern I have, well, I have more than just that, but I went to your Parks Master Plan, City's Livingston Parks Master Plan. School facilities are important resources for recreation facilities such as sports fields, playgrounds, and gymnasiums. Under existing resource, page 28, Parks Master Plan. Here is your map. And this is where, see the map? I think it's page 20 if anybody wants to go look it up online. This is Selma Herndon. This is the middle. This is the middle school. This is where the bars can go in. It is just a finger space on the map away from this public facility as a school and a park. I don't want any children hit by a drunk driver. And what I need is I need everybody leaving that bar to be sober if they're getting behind the wheel. That's my concern, and that's what I need to be addressed. The school is 18 acres, Selma Herndon, and the middle school is 9 acres. And this is page 29 of your existing facility of your Parks Master Plan. Would you put a bar right across from your sports complex? Just a block away? It doesn't make sense. And I understand the importance of having a business and all that, and boy, I'm pro-business. But I don't want to be killed. I don't want my children hurt, and I don't want anybody in my community killed. I think now that the acting police chief at the previous meeting stated that he knows people would be parking in Rite Aid to use the bar, you have opened up a litigation nightmare. If there is a parking lot accident, if there is an accident in Rite Aid, they might come back to the city of Livingston and say, look, I'm sorry, what?
I intended to give you the 1 minute sign, but 30 seconds ago you had about 30 seconds.
Okay, the acting police chief has now acknowledged it. You can't let people from one business park in another business without that business's approval. And if it could cause an accident, there could be, and you're an attorney, a liability. Bottom line, I want everybody to be sober if they drive. No drunk driving. I want no one injured. Not a child, not an adult, not even somebody using the bar. Those are my concerns. Thank you. And I'm not sure if it doesn't violate your Parks Master Plan, putting a bar that closely. Thank you.
Thank you. Anyone else?
Good evening, Bruce Rhoda, 707 Almond Drive. I just want to echo what some comments were made. I don't believe the appeal has any merit. I read the appeal, and I just think it doesn't have any merit and no room for discussion here. And I believe my understanding is that the person who submitted the appeal initially paid the $200, but then was refunded the $200 because of the capacity he was filing the appeal under. So that was brought up by a speaker earlier, so I'm not sure if my assumption is correct, but that's what my understanding is, that the person got a refund from the $200. Thank you.
Thank you. Anyone else? No? Okay. We'll close citizens' comments at 8 or 9, and we'll come back to citizens' comments for insurance comments.
No comments. I think we're ready for council deliberations, and we'll give you further advice as we go through the deliberations.
Thank you. Any council members? I just want to say that, I was the one that, was said, in COVID, I think I had some concerns on citizens in regards to voting for one against, and, I decided that it was best interest in the community because it was, of course, a great concern, and to appeal it. Previously I was public record that he came back, 2 months before he had applied, and, I voted in favor of it, so it's not like, they did it, but, I got to listen to citizens as well. So I voted for the project. I've never been against the project. And, I told the gentleman that I'm for business, and the majority of the council voted against it. I voted for it, so, there's a lot of issues that come up, attorney's fees and other issues that came up, the comments from the citizens that, that attorney's fees won't be paid, and just trying to address with the council and attorneys all those concerns from citizens. So, I think that there needed to be more answers given by the councils and the community. So that's why I deal with it. Anybody any other comments?
I will go ahead and make a few comments. I've had quite a few as Ms. Elgin came over and she rephrased what she had said prior to this issue coming forward before it was even an item in the planning. In regards to safety issues, I think we all talked about it, the safety on Main Street and the crosswalks, children coming and going to school, after school programs that kids are still coming through. I also think the parking is a very big issue. As I read through the information that we have before us, I noticed that there were concerns with the Tequila Club even before it became what we have before us. Drunk drivers with no doubt is going to happen, whether it's out of town or in town. But being that we have kids walking in the evenings, summer's coming around the corner, kids are out, they're out of school, they're out shopping, parents are out there with their kids. Definitely would concern me with the drunk driver. And anyone who tells me that they own a bar and no one comes out of there driving, getting in a car and taking off, they're lying. Okay, it's going to happen. And the thing is, you need, as a business person, if you have a bar or a club, whatever you might have, you are responsible for that person, the intake of alcohol and the security that person is not going to go kill someone. So I really think that drunk driving is something that putting a bar there is really just an extra way for drunk drivers to be around in our community. Other things that I noticed on the updated CUP with the conditions that planning did, hours of operations, they're not stated there. Whether it's days of the week, hours. Mr. Sperry, I know on your comments you did mention a few. I think Councilmember Lamb had asked what are the hours of operation. You stated them, but they're not on any of the conditions. They're not stated. They're on the original, but not on the updated one. So that's my concern too. Hours of operations, if it were to go through. PD impact, I think intern Chief Soria had spoken about this. The impact on PD, even if you tell me it's not going to have an impact, it is going to have an impact. It's going to have an impact because there's going to be drunk drivers coming out of the establishment. There'll be issues in the bar, whatever the issues may be, but they are going to come out to the street. and that's what really worries me. The other thing is the impact it'll have on PD, even if it's a 5%, 10%, that's taking away from our residential supervision. Our officers being out there, being able to, drive around our neighborhoods, because they're spending too much time in this establishment if it were to get to that point. I could go on and on. The littering on the sidewalks, using Rite Aid's parking lot, residents coming out from shopping, and there's a gentleman, getting in his car or drinking in the car and then going into the club. We see it all the time, and it will happen. Littering is an issue. And overall, like I said, I could go on and on, but there's quite a few things, comments from the planning commissioners that they kind of missed a couple of things. I commend you, Mayor, for taking the initiative to bring it forward, and definitely I think the citizens do need to know about it, and I think we need to be really careful when things go to planning, that the council actually needs to look at what they decide on. I don't think that you did anything wrong. So that's where I stand. I think we need this. There's a lot of questions that don't have any answers. All I can see is a lot of red tape there.
Thank you. Anyone else?
Mr. Mayor.
Go ahead.
If the mayor hadn't, I would have put it in myself. Furthermore, I read in the comments from Mr. Sperry that he couldn't figure out why it was coming back to the planning commission. It was turned down by the council, and the planning commission, along with you, Mr. Sperry, are the ones that brought it back. It wasn't the council brought it back. No, I'm serious.
I didn't ask for the December issue to be brought back.
Mr. Mayor, can we have? I'm sorry, yeah.
It was just the fact that it was written in the statements that he couldn't figure out why it was brought back. It wasn't brought back by the council, that for sure. And I have to go along with Mrs. Aguilar. Everything she stated. If you go back to when the Tequila Club was open, it was a problem for the whole length of time that it was there. And just saying that you can revoke the permit after so many months, we got told that, no, we can't do this, we can't do that. That piece of paper that says 6 months is not worth the paper it was written on. And the thing is, Rite Aid was calling the city hall, calling the police department constantly about that situation. And I saw our policemen out there all the time. And because of the amount of young people we have walking downtown, I really do not think that that's an additional thing, or a bar is not what we really need there. The other issue was that we stated that in our codes is that the open alcohol drinking, there is to be so many feet between each business. And there's already one serving it within 10 feet of that establishment. So, to me, my comment would be to do number 3 that says revoke the CUP.
I am also in agreement that I too was going to appeal this to bring this up to City Council. It was before us before we turned it down. It went back to Planning Commission and it has now come back to us. For the same reasons as Ms. Aguilar and Mr. Vieira state, I don't have issue with bar as a business. I think it's a legitimate business. My issue is the placement of the bar in the downtown area. It is too close to schools. There will be drinking and driving, public drunkenness. It just goes with the business of the bar. And I don't think that would be proper. We're going to have open market every week for about 7-8 months. Children will be there with their families. I don't think it's going to be good for the city of Livingston right there. I also think in close proximity to the schools, kids walking home from school. The hours, I didn't get a clear answer as to
what the hours of operation was going to be for the bar. The response that I got was, well, to start with, I would like to be open on these days at this time. That concerned me a little bit, because that was to start with. So that I had a little bit of issue with. So those are my concerns.
Thank you. Anyone else?
Mr. Mayor,
Go ahead.
just a question for Donna. I know in here the staff report says that since the bar closed, the existing bar, that it no longer complies with 1,000-foot. But this is Punjabi Suite serving liquor?
That's correct. Punjabi Suites is a restaurant, though,
So
and not a bar.
it does not comply, okay.
Correct. The closest bar was the El Diamante, and they did close during the process of business license review.
Okay, and, but I would also do want to do, thank you very much, that's all I have to do, is I think everybody in the community knows what happened when we had that other previous bar here. First of all, there is a parking is a major concern. And I don't want to give my decision, but I think ultimately, regardless of whatever decision the planning commission makes, city council is the ultimate authority. So I believe that is to be true. So if the council feels the planning commission erred in its judgment, it can call us up. And I think we've been very clear about this item. And so it's basically a review of the planning commission's decision. And council, I think, believe, in my view, I'm not an attorney, that council has the full authority to review any planning commission decision. Especially when it comes to conditional use permits, it's been done. And I am trying to avoid problems. I have nothing against drinking establishments. We don't need to go a place to unwind and relax. We have to do that. And I think I've spoken on that before. But I think it would probably be better for the applicant to try to find a way to mitigate this parking issue. There's some spots available. Go work out some sort of agreement with Ryan and says, can we use this? I mean, come in and alleviate some of the concerns of the city. I think that could be done. You know, just gotta show some place where you can park at. You cannot count on another existing business that gave no permission to be allowed to park there. No, you can't do that. So I think I know we're not ready to make a decision, and I think I want to give our legal time to review that. Those are my concerns right now. Thank you.
Thank you. Go ahead.
I definitely, like I said, we have information here that we didn't have this information prior to this meeting because we knew we had been informed that it was appealed, so therefore we wanted to just keep neutral. Now that we have the information, I just wanted to let the residents know. One of our residents asked who was going to pay for the $12,200 that were already accumulated because of this establishment and the paperwork, lawyers, everything that needed to be planning, the whole works. And Mr. Sperry's comment was the following, which is on page 7. Those of you by chance have printed this out. It said, Mr. Sperry added that on December 17th, his attorney sent a letter to the two city attorneys, Donna Kenny and the city manager Ramirez. He stated that the $12,200 bill is not it, but the bill will increase, and that is only the beginning. He is costing the city money. He has not even started to generate money. Who will pay for this? The citizens will pay for this. And I mean, if you're coming in to kind of establish yourself, you do not put a tag and expect the resident to take it or leave it. And with this comment, it just really tells you what we're dealing with. He continues saying that he thinks that the planning commission should just say that the parking requirement has been met. he wanted Director Donna Kenny to sign off on his business license, and it would end tonight. So he's asking one of our head of departments that serves all of you, he's asking her to lie. That's what it is. So I just want to make sure you guys know that. You go back, and I've highlighted it, and it really disturbs me that he would actually have said that, and it's so clear. Okay. Thank you so much.
Thank you. Well, I just want to state, in regards to the conditions of approval, I know that the council would like to modify conditions. There's always, one or two more conditions that we could add. And one of my requests would be that the operator should steam clean the sidewalks once a month in front of the business side of Main Street and Lee Street, because I think that we keep our sidewalks on Main Street, and being that it's right in the main corner of a crossing in the downtown. So I think that would probably be one of the conditions to add on there. Also, too, maybe a couple of trees, because I know some of the trees are pretty old as well. I want to thank the Planning Commission. I know they're doing a great job. They're also pretty new. They have been on the Planning Commission for a long time, so not that they have their own mind. I think they're doing a good job just addressing all the issues. But they're not there. They haven't been there for a long time. But we just want to address that. We value them, but also too we have to address the citizens' concern as well. I know that mostly the citizens call the city council, not the planning commission. So we have to probably let them do their job, and then when it comes to the council, we have to address the citizens' concerns, and that's what we're trying to do. So thank you. With that, I have that's what I have.
I have two comments too.
I just want to finish up my thought. In regards to the reason I read that, I totally forgot this little note I had there. We need to, as council members, even as the planning department, we need to make sure that we have in place, it's called a reimbursement agreement with the applicant, meaning that if an applicant brings a plan forward, they are bound to that plan, and they are in agreement that they're going to pay the fees that are required on their behalf. It's not going to be on the citizens. And that's something that we need to make sure we address, not just with this establishment, with anything else, anyone else who else comes forward, because we get stuck with the tab. And in this case, the citizens have to pay that. And like I said, it was maybe something was overlooked. We didn't have that in place. We need to cover ourselves. And that's why I'm saying the reimbursement agreement with applicants needs to be part of the CEP when if we decide to go ahead and move forward with this establishment or any other from this day forward. That's just my recommendation. Thank you.
Thank you. I think we have a
Sure. Mayor, if I may just summarize where it appears the council is in your work on this matter tonight. You have 4 options that are before you tonight. They are the same options that were before the Planning Commission. So far, just to summarize the comments that we've received from the council members, 3 council members provided comments that appear to suggest that they may favor option 3, revocation of the permit, rather than working on the condition. From the comments that we received so far, 2 council members instead started working to see if there were conditions that could be modified to make the permit acceptable and to further modify the existing permit. That would be option 2. What I would suggest you do tonight is to work a bit more as a council and deliberate a bit more as a council. If those are the 2 options, if I'm correctly interpreting the comments I heard from the council, that those seem to be the 2 options that you're focusing on as council, I'd keep working on those a bit further, and figure out as a council initially where it appears a majority of you end up landing on this. And it seems like it may boil down to, do you think that the conditions can be improved enough that you would favor approval, or in fact do you want to go ahead and revoke? If you do want to go ahead and take either one of those 2 actions, again, this is an important process. The applicant's comments about participation and notice and the sincere intention of your code and this council to give full participation in this process, I do think, is exactly why we would come back with findings that would be draft, that would be in the staff, that would be in the packet, that would be, included with the staff report. And I would go ahead and further even offer that you go ahead and keep the public hearing open again and allow the public, if you're inclined, to speak on the item briefly again and take a look at the final findings and take a look at the final staff report. There really should, I don't think that there is any issue about the public notice already as it exists, but I think that there's a sincere desire by this council and the community to give full public participation. So if the council feels that it would be appropriate to do, I don't think you're required to do that, but that would certainly be going above and beyond the requirements to allow public participation. So the public could all take a look at the findings and could comment on them, and the council could carefully review them before we adopt it.
Yeah, no, we have a lot to take and address, but still comes back to attorney's fees. We can go back and continue this item and look at more of the issues, but also too, it comes to he hasn't signed any agreement with the city in regards to attorney's fees. He said I'm not responsible for any attorney's fees, and he's right. That if he wants us to move forward, he's got to be willing to every developer, every person who comes into the city say, it is time consuming. Attorneys have to work together, and the city is going to spend more money. So if he my point of view is that if he doesn't want to sign an agreement where he's responsible for part of the fees, which it's been over $12,000 already. I don't know if there's any sense in continuing this item, or making a motion, because that's my opinion.
Mr. Mayor, since we deliberated, I think we should give one more opportunity for the public for the input, so we can consider that our deliberation, what the response is. So I think I would like to see it open up one more time for the public, including the applicant, of course.
Again, Councilmember Mayor Espinoza.
Please.
That is an absolutely legal appropriate course. If you want to not give any direction here tonight and instead to just continue the item and without giving staff any direction, the council could choose to do that. Alternatively, you could give and I think staff's recommendation would be at most to give to make a motion that would give initial direction as to one of the options, and it would be initial direction to write a findings and resolutions that would implement one of the options. It would not be to take final action tonight. But if instead you wanted to do as you just suggested and just continue it before giving that direction, you could certainly do that. I think in reality it might actually help kind of focus the council's discussion if you have a set of draft findings for one of the options in front of you, and I think that they would help the applicant see exactly what the basis potentially for the council's conclusions were, and kind of pull together the information that's in the record that's already been discussed for the council.
I agree. I think if we allow the public to comment one more time, then we can bring it back, and then we can very much do what the comment is of the attorney and give some sort of a direction and come back with the findings. We can make our decision at that later date. And what I want to do is, now that the public has heard our deliberation, our concerns, gives them a chance to respond. So I think giving another few minutes probably wouldn't be a bad idea.
Yes.
Okay. I'll go ahead and open up the citizen council again at 8:32.
Catherine Shell, Rodriguez, P.O. Box 163. I was at that planning commission meeting, and I was the one that raised the issue about the $12,000 in such an attorney's fees. The explanation that I was given is that the city spent extensive amounts of time researching the history of the Tequila Club and the paperwork involved. And because of the extensive history of the Tequila Club and prior uses of the project, a whole lot of attorney time got burned going through all of that. If that is the case, that's not necessarily the applicant's fault. That is just one of those things that happens because of projects in the past, the way CUPs were done in the past, the way paperwork was kept in the past. Anyone who's ever done any tracking or requesting of documents going beyond 2004, you often hit what we jokingly refer to as the black hole. I do not think from the explanation that was given, and I was there when that explanation was given, that that large amount of money was necessarily the fault, or whatever word you might choose to use, of the applicant.
Thank you.
Thank you, Mike Ward again on behalf of me. I'll call on the applicant, but first, let me clarify. One council member referenced that this matter was before the city council earlier last year.
Excuse me, I'm sorry, I need to interrupt and we reset your clock. Can you state your name a little more slowly?
Yes. Mike Ward, W-A-R-D.
Thank you, sir. Sorry, I didn't mean to interrupt.
No problem. There was a matter that was before the city council, and it was, I believe, it was in 2011, and I think according to your staff report, it was May 3rd. And what the council was considering at that time was the distance between bars, the 1,000 feet distance that was required between bars. It was not a consideration of this particular business. It was a decision that would impact this business, but it wasn't this business, and it wasn't an application. The other thing is that I've never written a letter indicating that there are fees that have been spent, there's going to be a lot more fees that are spent. That's just absolutely untrue. I think there's no letter that exists in the file that I've written to anybody indicating that there's going to be more fees that are going to be spent. This is not the application of Mike Sperry, by the way. Mike Sperry applied for a business license last summer. It's a very simple process. Had the council followed that process, had the city followed that process, we wouldn't be here today. The reason that we're here today is because the city, on its own behalf, brought the CUP before for consideration of revocation. So Mike is not the applicant, and he would have never been required to sign any kind of a reimbursement agreement based on that. He's not here requesting a CUP. He's not here asking to modify the CUP. He certainly didn't file an application to have the CUP revoked. This is a staff-generated, a city-generated application. So Mike Sperry shouldn't be blamed for it, and he shouldn't be singled out, maybe made to look like the public enemy of the city of Livingston, because he's not. In almost every city that I've worked in, the downtowns are rejuvenated slowly by clean operations, oftentimes include alcohol service. It's happened in Turlock, it's happened in Odessa, it's happened in every nice downtown that started to redevelop. And that's what brings these things down. Now, if you want to consider hours of operation restrictions, Mike Sperry is open to that. If you have conditions and conditional conditions, and we can work through this, we are open to that. If it's a meeting that you encourage staff to have to come up with some conditions to propose to you, we are open to that. But no one's ever, again, Mike's been on the defensive on this thing the entire time. Mike has had to hire the attorney to defend himself. He's not here hiring an attorney to force the city to do anything, except for comply with what the city should be doing when it moves forward. So again, however you decide to move forward, obviously, we are here to try and find resolutions. If the bar opens, for example, at 5 or 6 p.m., school is out. And I don't know that there's any other locations in the city of Livingston that are not somewhat near a school. And so unless you plan to prohibit alcohol service in the city of Livingston, this is an issue that you have to fix. And we might as well face it, developing good conditions and things that work for the city, and having a review process. I disagree that the conditional use permit paper is just a piece of paper. It's it grants rights to people, and it grants rights to the citizens too, because they can review a process by filing complaints with the city. And the city can come back and say, Mike, I'm sorry, but your operation is not good for the city because of X, Y, and Z. and we're going to revoke your permit, or we're going to add additional conditions. I mean, we intend to comply with the terms, and I know the city does. I think people are frustrated sometimes, and those comments may be a result of frustration, but again, if we can work to resolve this, that's our preference, because it's easier for everybody. Thank you.
Thank you. Mr. Armstrong,
Go ahead.
First, staff, if the council chooses to give us direction to meet with the applicants and work with them, I presume the city manager's office is happy to do that, or willing to do that. But it is not consistent with the record to characterize this as a staff or council directed process. And let me please finish my comments. The staff report explains that there was on page 1 and 2 of the staff report that the council has in front of you, in February 2004, for the then active bar use under the CUP on the property, an active process of permit review, issues being raised, and the modification of the permit being required, and that there was, in fact, an active review process going on with the Planning Commission. The Planning Commission, and I'm going to read from the staff report just for the benefit of the public. The Planning Commission adopted a resolution requiring additional review of the CUP after, let me start again. Just reading from the staff report. Most of the complaints pertain to people congregating, drinking, and littering outside of the club Tequila and in the neighborhood-rated parking lot. In response, the Planning Commission adopted a resolution requiring additional review of the CUP after 3 months. There is no record of a subsequent review of the CUP. Presumably, the club closed down prior to the next review. So that's from the staff report. So what it appeared to staff has occurred, and what the record we believe will prove out is that this was before the Planning Commission for review of, it appears, precisely the same kind of public policy concerns, health and welfare concerns, safety concerns, littering concerns that many of the council members are talking about. This was before the Planning Commission, and you were called back on this CUP to have a subsequent review, and instead the bar closed. But those issues, that evidence, those problems, those concerns that were supposed to be the subject of a follow-up review 3 months after those prior reviews were happening in 2004, instead never happened. And the next action by the applicant, by the owner, it appears, was an application for a building permit. And so for the applicant to here tonight to act as if it appears there was nothing that happened before the Planning Commission, and that it's somehow wrong of the City Council or the Planning Commission to take back the issue that went dark for those so many years as if there had been no issue, I don't think is a correct characterization of the record as it appears before the city.
Let me be clear, I've never said that the council is active.
Oh, sorry, I think your 2 minutes were up already, so,
It'll be brief, there are 30 seconds or less. I think he's made a comment, and I think let me just respond 30 seconds and I'm done.
30 seconds.
The comment, the situation that council's referencing occurred in 2004, some 8 years ago. That's number one. Number two, there was no notice set for the hearing to consider the revocation, the modification that addressed that. That hearing was originally set for a consideration of, it was either the parking requirement or I think it was the parking requirement. That was the purpose for going there. And what happened was in my communications with one of the attorneys that was representing the city, when we agreed that there was a problem with the parking, that condition could not be imposed unilaterally on this applicant. Somehow, the business application process turned into a permit revocation process, a conditional use permit revocation process. And Mike Sperry has never been the applicant under that process. There is no application before you signed by Mike Perry, and that's who's here today, based on something that started with the business application process. I have not indicated that the city has done anything wrong. I just simply responded to the fact that there was a reason why Mike Sperry has not entered into a reimbursement agreement for a conditional use permit. That's the only point I was trying to make. Thank you very much.
well, I don't know if it's true, but I thought I had heard that he had requested he the city council was to be heard. It was for the CUP. He addressed the planning commission, and they're the ones that called it up because he requested to them, to be heard. And so that's how the CUP is here. And we were surprised because we didn't know that the planning commission had put it on the agenda. And now we're reviewing that.
Respectfully, you don't have anything like that, no applications from Mike's Berry at all. All you have is a business license application.
They can
Mike's Berry did not apply for.
I'm sorry.
shouldn't be talking.
Yeah, thank you. Thank you very much. I'm sorry about that. Go ahead, sir.
Good evening. Alex McCabe, Livingston Chamber of Commerce President. The Chamber does not have any opinion whether or not the alcohol should be served downtown or regarding the alcohol issue here. The only concern we have is the revitalization of the downtown and the parking concerns there are. There are 2 vacant buildings downtown right now. And at this point, I'm not sure what businesses I can encourage to come to those locations that would meet the current standards when it comes to our parking requirements. So I'd just like to encourage the City Council, which has been very pro-business so far, to maybe direct Donna Kinney when she has her workshops about codes, to reconsider their codes when it comes to parking. The Chamber does not want to make a comment regarding the alcohol use, but we do want to make a comment about the future use of those buildings. And for our commerce, we need to have businesses in those buildings. That's what's better for the city of Livingston, and so we need to readdress at the workshops for the future of parking concerns and address them. So eventually when people come to me and say, Alex, what can I put down there? I can tell them anything. Thank you for your time.
Thank you.
Good evening. Bar number 1331 8th Street. Start off with, schools have been here for years in these locations. When we had many bars here in town. In fact, there was a toss-up between bars and churches. And we had children running around in them too. What we have here is a bar for a businessman that wants to put in a bar. The Planning Commission has put conditions on the bar, and you also have state laws that they have to go by. You have an owner or a businessman that lives here in town that wants to put in a business there or have a business there, and he's going to do everything under his power to make sure that it's a go, and there's no drunks in there, and I'm pretty sure that whoever's working the bar and there's going to be checking the people to make sure they're not under the weather. And he wants to make a go of it. And like I said, with the conditions there, they're set, and the state sets hours, and he can take less hours for his operation, and I don't see any reason why he shouldn't be able to operate here in the city. So I recommend you do approve it, and that's enough. Thank you.
Thank you. Okay, last comment, and then we'll close the citizen's house.
Luis Suarez, 107 Alcoholic Drive. I just want to address the littering, polluting, loitering comments that were being made. I believe those comments were in reference to a previous owner, and it has no relationship to Mike as a business owner, the history of Mike as a business owner. So those comments about there's going to be littering, there's going to be loitering around this business, does not relate to Mike. So those, you can't really correlate something that happened 8 years ago with different people with a different business model with what Mike is proposing or this applicant is proposing. So I just want to make that comment. And I forgot to do a comment. And I have like 2 more minutes, so maybe it'll come to me. All right. Oh, yeah, sorry. Now I have a minute. So there was a comment about school-aged children passing by this establishment, where every day when I go to work and when I come back from work, there's school-aged children passing by Mountain Mike's, which have big signs of alcohol outside of its establishment. And they're open early and they're selling alcohol, and that's only a few feet from this establishment. On the other side of town, we have Yamato that's closer to Gino's, and this establishment is closer to Summer Herndon. So if we're talking about sort of the proximity, the accessibility of school-aged children, regardless of what season it is, if it's summertime and they're out and about, we already have these other establishments in place. Gino's is close to Yamato. Mountain Mike's is close to Summer Herndon, and these two sites are close to businesses that sell alcohol, Sam's, Liberty, and Rite Aid. So, yeah.
Thank you very much. We close the citizens' council 849. Council, any discussion or motions?
So again, if there is not a desire by the council to further deliberate here tonight, I would encourage you, based upon the discussions that you've had, to consider making a motion to provide initial direction to staff to draft findings and a resolution to implement one of the options, and then to bring it back to the council for a future meeting.
You do that, or you guys want to make a motion now?
Again, that's appropriate for the council to deliberate further if you want, or go ahead and make a motion for for us to write up one of the options and bring back to the council.
At this moment, being that we do have the option, I'd like to make a motion. I'd like to make a motion to option number 3, which is to revoke the existing CUP.
And I'll second.
We have first by Councilmember Mayor Espinoza and second by Councilmember Vieira. Can I roll call, please?
Councilmember Vieira?
Yes.
Councilmember Land?
Can I just be sure I heard the motion correctly? The motion was to provide direction to staff to come back. It was not to take final action to revoke. Yeah, let me just be clear again. The requested action here is not to take final action to revoke, but just to provide direction to staff to prepare findings and to bring back a resolution for you to consider at a future meeting.
Will we still have
that would be
conditions?
consistent.
Will these conditions still apply to the options that we have
Yeah.
before us?
Yeah, what the process we're going through is to try to narrow down where the council would like to, things that it would like to land, so that if your motion would simply be not to actually revoke the existing CUP tonight, but to direct staff to prepare findings and a resolution for you to consider at a future council meeting for revocation of the use permit.
Yeah, any of those four.
You have all of those options, but our advice to you is simply that you're not taking final action here tonight.
Just direct the staff to
write up the findings and to bring back the item, and then you would vote on it at the upcoming meeting.
That's what I understood when we were making that you were going to work on this as the option that we wanted.
I wanted to be
clear. I didn't think we were passing anything today.
So then you're referring to option number 2?
No, 3. He's going to write up number 3, but we're not making the decision tonight. That's what I got.
To go with option number 3, and you second it.
Yes, but that's just the decision.
To come back with findings.
Findings and resolution.
Mr. Mayor, can we have the motion restated, please? Just for clarification.
Sure. Could I restate the motion then, as I understand it?
Yes.
The motion would be to direct staff in the city attorney's office to prepare a resolution, findings, and staff report that would recommend the revocation of the existing CUP consistent with option 3 in your status report. And that there would be no action on that, there would be no final action on that revocation here.
Okay, he takes back the, you retrieve the motion, right?
Yes, that's exactly the way we do it.
So would
And
you
we're
like to
going to find
move
a
that,
decision.
then you would move as
Move as
stated by the session?
By the city manager.
And that's the way I second.
Oh, sorry. I'd like to move on as stated by our city.
Second by Councilmember Villar. Everyone roll call, please.
Councilmember Vieira,
Yes.
Councilmember Land,
Yes.
Councilmember Samra,
Yes.
Mayor Pro Tem Aguilar,
Yes.
Mayor Espinoza,
Yes.
pass 5-0.
Thank you. Now, we're on item number 2, introduce and waive the first reading of the ordinance for the city. No, we know, can you take that short comment there?
Mr. Sanchez has.
Oh,